start. But it is also correct that even though the plea of alibi of the appellant is not established, it was for the prosecution to prove the case against the appellant. To this extent, the submission of the learned counsel for the appellant was correct. The failure of the plea of alibi would necessarily lead to the success of the prosecution case, which has to be proved by the prosecution beyond reasonable doubt. Being aware of the aforesaid principle of law, trial court as also the High Court examined the circumstantial evidence to exclude the possibility of the innocence of the appellant. The mere fact that the accused were residents of a village at some distance would be inconsequential. As per the statement of the witnesses, both these accused were seen by them in the house of Ratiram, where the deceased was murdered. We are also unable to accept the contention that presence of PW10 and PW11 at the place of occurrence was doubtful, and the statements of these witnesses are not trustworthy. It is no doubt true that when an alibi is set up, the burden is on the accused to lend credence to the defense put up by him or her. However, the approach of the court should not be such as to pick holes in the case of the accused persons. The defense evidence has to be tested like any other testimony, always keeping in mind that a person is presumed innocent until he or she is found guilty. While analyzing the plea of alibi so sought to be raised by the appellants, this court finds that the appellants have not been able to prove beyond doubt that nobody was present there at the time when the unlucky occurrence took place, as the circumstances prove otherwise, which has been already discussed in detail. Much emphasis has been laid down by the learned counsel for the appellants that the dying declaration of the deceased is not reliable, and the same cannot be put into motion while convicting the appellants. Elaborating the said submission, learned counsel for the appellants had argued that in the present case in hand, dying declaration was recorded by the police personnel, and further the certificate of fitness was also not obtained from the doctor, and there is a cloud regarding the fact that as to whether dying declaration was recorded or not, as according to the learned counsel for the appellants, the deceased was in a critical condition and he might have died before recording of the dying declaration. Dying declaration gets its root from section 32 within bracket 1 of the Evidence Act 1872, which reads as under: when it relates to cause of death, when the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question. Such statements are relevant whether the person who made them was or was not at the time when they were made under expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into